Welcome to a concise historical journey into the foundation of the modern Ghanaian legal system, the introduction of British jurisdiction into the Gold Coast. This journey is marked by pivotal legal and political developments over a century and a quarter. We will trace this evolution through 20 key dates, with a focus on 11 that fundamentally reshaped the legal landscape. The process began in 1821 with the passing of the West African Act. This act saw the commencement of the introduction of British jurisdiction into West Africa. Crucially, it joined the administration of the Gold Coast to Sierra Leone, creating a centralized government. By 1828, the British handed over commerce on the Gold Coast to the Committee of Merchants. To facilitate this commerce, George Maclean was appointed governor in 1830. Maclean's primary move was to persuade local leaders to sign a peace treaty known as the Peace Treaty of 1830. Before any formal jurisdiction existed, Captain Maclean exercised a kind of irregular authority widely known as the Protectorate. This territory was not a British possession, having never been conquered, purchased, or ceded. The jurisdiction he exercised was irregular, but natives, whether chiefs or traders, voluntarily submitted to British equity, which inspired respect due to its fairness. Maclean himself proposed that the monarch and parliament needed to formalize the authority in the Gold Coast. This led to a parliamentary committee being set up in 1842 to review his proposal. The committee submitted its recommendations in 1843. In response, Parliament passed two key pieces of legislation, the Foreign Jurisdiction Act and the Settlement Act. This formalization culminated in the Bond of 1844. Historically, this bond is the foundation of the Ghana legal system. Publicly, the British promised protection to the signatory Fanti states against the Ashantis. The underlying main reason, however, was to legalize their jurisdiction. The bond contained three critical provisions. Clause 1 confirmed the vesting of powers and jurisdiction in the British monarch, and the signatories acknowledged that the primary object of the law was the protection of individuals and property. Clause 2 prohibited human sacrifices and other barbarous customs, such as panyaring, declaring them to be abominations. Clause 3 stipulated that serious crimes like murders and robberies will be tried before the Queen's judicial officers and the chiefs, molding the customs of the country to the general principles of British law. The immediate effect was striking. By 1846, the Queen's Court saw higher numbers of cases than the native courts, even for matters that should have been dealt with by local authorities. This marked the beginning of the recognition of the British judicial system. In 1850, the Gold Coast was finally separated from Sierra Leone. In 1853, the British established the first Supreme Court within their forts and settlements, based at Cape Coast. This court's jurisdiction was similar to that of the Queen's Bench, Common Pleas, Exchequer, and the Admiralty in England. A major turning point came in 1874. Following the defeat of the Ashanti, the British established the British Crown Colony of the Gold Coast, incorporating the Fanti states and the newly conquered Ashanti domains. As part of consolidating this victory, the Supreme Court Ordinance of 1876 was passed. The ordinance was instrumental in establishing a Supreme Court for the Gold Coast colony. It is this ordinance that established the modern Ghana legal system. The ordinance had several critical effects. It enlarged the exercise of British jurisdiction, it abolished the judicial assessor system, and it created a dual system of laws. The received English law, which is common law, equity, and statutes of general application, and the customary law and local legislation. Most importantly, Section 14 provided that the common law and the doctrines of equity enforced in England on July 24, 1874, which was the date the colony obtained a local legislature, would be enforced. The court system under the 1876 Ordinance consisted of the Court of Appeal or Full Court, constituted by any two Supreme Court judges, one of whom had to be the Chief Justice, Second, the Divisional Court, which was constituted by a single Supreme Court judge exercising the original jurisdiction. The full court's decision was by majority, but the ordinance failed to provide for an equality of votes. This created a recipe for uncertainty, as demonstrated in the case of Beni and Danchi, where a four-judge court reached a stalemate on whether chiefs could lawfully exercise their judicial powers. The question remained unresolved. In 1878, the first Native Jurisdiction Ordinance was passed to control native authorities in the Protectorate. Although it was allowed to lapse, it was repealed and replaced by another ordinance in 1883. This system was later amended in 1910, establishing various grades of native courts, and amended yet again in 1927. The subsequent years saw continuous evolution. The Local Courts Act 1958 transformed the native courts. The Courts Act 1960 placed the local courts at the bottom of the hierarchy. The Courts Act of 1971 created a unified system of superior and inferior courts. The 1992 Constitution eventually abolished the temporary dual system of regular courts and public tribunals, restoring the integrated system that largely remains today. The process formally concluded with the Independence Act of 1957. The historical foundation of the legal system clearly reflects the country's colonial heritage. The challenge today remains to constantly appraise this legal heritage and adapt the system to meet the complex socio-economic circumstances of the nation. This concludes our summary of the introduction of British jurisdiction into the Gold Coast. I encourage you to master this information and visit my YouTube channel, The Law GH, to watch the concise version of this topic to further appreciate the development of our legal system. Prepare for the set of questions to follow.